During the course of pretrial questioning in your medical malpractice case, the defense attorney has been itching to ask you this question from the very moment she started questioning you. And what's the question? Hey, Mrs. Jones, tell me why you really sued my client, the doctor, in this case. And you know what I say to that? Objection! Don't answer that question. You want to know why? Come join me and let's walk through the neighborhood as I share with you exactly why I tell my client, don't answer that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, you decided to bring a lawsuit against a doctor whom you believed was careless, causing you significant harm and injury. A medical expert that we hired to review all of your records confirms that your doctor was careless, confirms that his carelessness was a cause of your injury, and confirms that your injuries are significant and permanent. All three of those things have to be present in order for a medical expert to confirm that you have a valid basis for a case. Okay, so what happens next? During the course of your lawsuit, the attorney who represents the various doctors whom you have sued will now have a chance to question you in our office. This is known as a deposition. We also call it an examination before trial. It's really nothing more than a question and answer session that's given under oath. But you should know something. There's no jury there, and there's no judge there. But the answers that you give carry the same exact weight as if you are testifying at the time of trial. Now, there is a court stenographer who's going to be in the room, who's going to record all of the questions you are asked and all of the answers that you give. During the course of your questioning, the defense attorney, I can tell, has been itching to ask you this question. And what's the key question? The key question that I know she wants to ask is, Mrs. Jones, tell me really, why did you sue my doctor? He believes nothing was done wrong here. So tell me in your own words why you sued him. And you know what I say to that? Objection! That's a palpably improper question. I direct you not to answer that question. And now the attorneys are going to get into a verbal sparring match. We're going to be fighting and arguing over whether or not my client has to answer that question. Here's the argument I would make in response to that attorney's question. Counselor, I object to that question. It's inappropriate for this witness to answer. That question calls for medical expert testimony. And clearly my client is not a physician. My client is not a medical expert here. And now that calls for evidence. Medical evidence from a medical expert as to why your client violated the basic standards of medical care, causing her significant harm and injury. So, because she is not the medical expert in this case, and because she has no medical background, I am not going to allow her to answer that question. If you want to rephrase the question to try and get other information, by all means go ahead and do so. But to ask her why she sued the doctor, you can ask my expert that at the time of trial. So why do I share this great information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases here in New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207. or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.